is Marci Seville. Some of you know me because I teach here, and we're actually going to switch up the roles a bit. And Amy Jensen is going to moderate instead of me, and I have turned into the plaintiff's lawyer on the panel. So I'm going to turn it over to Amy.
Great. Hello, thanks for having us today. We are here, the ABA sponsors this event every year for us to come around to the law schools and speak with law students just to kind of let you know about the practice of employment law for those of you who are interested in pursuing that career, because there are so many ways that you can use not only a law degree, but there's so many different ways you can practice employment law. And it is one of the hotbeds of practice. There's a lot of sensational employment stories and big verdict cases, and also very important transactional type work that gets done in this area. So we're here today to tell you about the various ways that you can practice law. Or we'll talk a little bit about our own practices, because we all have extremely different practice areas, even though we're all employment attorneys. We'll talk a little bit about things like work-life balance and what you can expect when you get out of school and when you get your first job. And then we'll also talk a little bit about things like networking and how you go about making the contacts so that you can get that job, and what to do when you might not get the job you want, but how to still keep pushing towards your favorite career in employment law. So I'll ask Matt, will you please just briefly introduce yourself?
My name is Matthew Gilder. I work with Sedgwick. My area of practice is ERISA, where I work with qualified retirement plans, not the welfare plans, which are really common.
And my name is Frank Sue. I work for Brisbois in San Francisco. I practice workers' compensation defense, which is a very specific subset of employment law. I represent employers, insurance companies, self-insured entities in the defense of workers' compensation claims.
My name is Christina. I am with Beazley Insurance. What I do there is I work in-house and I manage claims. So I'm trying to think of the quickest way to explain. So a lot of companies, what they'll do is buy what's called employment practices liability insurance, and not all, but many do. And when they do, they have coverage, kind of like you have car insurance. So if you get in a car accident, you have coverage to pay for the damages to your car. Employment practices insurance helps offset the cost of the defense, the cost for the attorneys to defend against an employment claim. So what I do is I manage those claims for the insurers, our policyholders, and I can answer questions if anybody has any later. But basically, I don't technically practice anymore. My company decides to pay for my license just because they're nice, but I technically am not practicing law, and I have to get separate licenses to do adjusting, claims adjusting, like a claims adjuster. So.
And I work in the traditional sense of labor and employment defense. So I handle discrimination cases, harassment, retaliation, wrongful termination, things like that, handbooks, counseling and advice, the typical things that most people think of when you hear employment law. It's kind of the garden variety vanilla employment stuff, except for I only represent companies. I never represent people. I'm always on the defense side. I'm never suing any employer. But then, Professor Seville, it sounds like you've had some experience on the other side.
About a third of you are probably my students or former students. I'm here and I direct the Women's Employment Rights Clinic, where we run a program on campus doing largely plaintiff side representation of low-wage workers, so people who don't have a lot of other options in terms of going out and retaining counsel. And we also do policy work, we do legislative work that some of you have participated in. But as we talk through the program, I've had actually quite a wide range of experience in different kinds of plaintiff or union side work that we'll be talking about.
That's great. And so one of the things that you might notice from the outset is that we are not all litigators. Matt, do you ever see the inside of a courtroom?
Never.
And Christina doesn't anymore either. So if there are any of you out there who are terrified of standing up in front of a judge, or who do not ever want to be on the spot and have to answer weird questions of law like you do in class, you don't have to. You can easily practice employment law and be in a very specific field like Matt, where he's doing a lot of tax work. with his employment, so he can use financial skills in connection with his employment law. And Christina, who has her legal and attorney and litigation background, but she's actually using it in a very different way operationally inside of an organization. So, and that also, not only does that affect the way that you practice and where you might be practicing. For example, Matt, when you deal with any sort of agency or governmental body, who are you dealing with?
I deal with really only two agencies on the most part. It's the Department of Labor and the Internal Revenue Service, depending on what issue is being, what we're talking about. From my standpoint, I deal with employee benefits, which includes executive comp. So a lot of the time, I'm sitting out by my phone waiting for clients to call me, or I call them and ask what's going on with their client, what's going on with their certain projects that I'm aware of. So they would only bring me in upon an audit of the IRS coming in and looking at a client document, or the Department of Labor might be looking at certain things, certain abuses or problems. But a lot of the time, I get those before the audits occur and fix them way before, years and years before the Department of Labor ever sets foot in there. So in fact, I'm sort of a quasi-enforcer.
So sometimes you don't even have to deal with these, you don't have to go to court or deal with agencies and stuff, whereas someone like Frank, who do you deal with in the government agency-wide?
I deal with the Workers' Compensation Appeals Board, and there are district offices all over California. There's one in San Francisco and Oakland, those are the closest ones, but there's multiple offices throughout the state. My office covers pretty much everything from Fresno all the way to Reddit, so I do a lot of driving part of my job.
Now your courts are a little bit different than what we are mostly accustomed to. I don't know if any of you have ever been in court or had an opportunity to observe a civil case, but workers' compensation courts are different. It's called the board. And so maybe you can explain to us how, because Frank's actually practiced on the employment defense side as well. So he was a civil attorney who went into workers' compensation. So he's got experience in both fora. And so he might be able to explain, because they are very different. And Frank, maybe you can also talk about the fact how sometimes your opponents aren't even attorneys.
Sure, that's right. It's very different. It's administrative law, not civil law. So you're dealing with workers' compensation judges. They're supposed to be kind of on the same level as superior court judges, but in reality, it's a little bit less formal. The rules of court are more relaxed. The rules of evidence are more relaxed, and the dress code is a little more relaxed sometimes.
A little more informal, right?
A little more informal. It's not a traditional courtroom where you walk in and there's the jury box, and the plaintiff side, defense side, and then the judge is up on a bench. It's almost, some of these places, district offices are in like a regular office building, and you just walk into a room that looks just like an office suite, and you just deal with the other side, and you try to resolve your case, and if you can't, then you go see the judge in his office. So it's a very different type of practice. And you were mentioning that sometimes your opponents aren't even attorneys. In workers' comp, you're allowed to have non-attorney representatives, and primarily on the plaintiff or applicant side, where the attorneys get they have a flat fee of 15% on the case, so it's a lot less than civil cases. So they need to take a lot of cases to make profits. It's high volume business. So a lot of times they'll hire non-attorneys to appear for them at the board.
Right, and that's kind of weird, because you expect when you're a practitioner to always be dealing with opposing counsel, and sometimes in Frank's line of business at least, you're dealing sometimes with the applicant themselves or a hearing rep who is not a lawyer. So that shows you where you need to sharpen your communications and negotiations and counseling skills. Now, Professor Seville, I heard you say something about unions. So have you been before the NLRB?
Yes, we don't generally do, so I'm going to try to unravel the initials, because everybody may not know. One of the things in any field of law is you either get abbreviations that are 187s in criminal law, or these initials, alphabet soup. So the NLRB is the National Labor Relations Board. We have a student work there one summer. And that deals with union management relations. So we don't deal with that extensively in my current job, but I was previously I was an in-house union lawyer in the public sector, which deals with a similar agency in the state called the Public Employment Relations Board. And in the current job, we deal with various anti-discrimination agencies, which include the California Department of Fair Employment and Housing, the DFEH, the Federal Anti-Discrimination Agency. Anybody know what that is? The EEOC, the Equal Employment Opportunities Commission. And then we deal with the Federal Department of Labor and the State Labor Commissioner. Those are primarily the agencies we deal with. We deal with the Unemployment Insurance Appeals Board and people have benefit appeals. So I think one of the lessons from this initial part of the conversation is you want to be a labor and employment lawyer, you need to know administrative law. You need to know what agencies are, you need to know what regulations are, you need to know what the administrative procedures are, and I think that is something that frequently gets lost in your legal education unless you take a particular course in it. You don't realize how important in employment or environmental law the administrative agency process is.
That's very true, and I think that, you know, I can easily tell you that I could not do what Matt does, even though we both have similar backgrounds in terms of we went to law school and graduated and have these advanced degrees and have been working for 10 years. I don't know anything about ERISA. I couldn't tell you the first thing about it. So there's definitely very different ways that you can practice, different agencies you're before, and sometimes you don't go before any agencies. Christina, you don't go to court, right?
Not anymore. Kind of nice.
So just generally speaking then, what's a day for you?
So to give a better sense, when I say I manage claims, you kind of have to understand the process. So if somebody has a EEOC, Equal Employment Opportunity Charge, filed against them, they'll probably receive it with a notice in the mail. And if they understand their reporting requirements under their employment practice liability policy, which is EPLI, they will then report it to us. And when it's reported, we have a process where it gets assigned to different adjusters based on various criteria. Each company is different. So when it gets assigned to me, what I do is I make an initial contact with the policyholder and figure out what's going on, what's the status with it, work with them if they don't already have defense counsel with finding somebody to defend them and help them in responding to the charge. And after that, my role kind of links off. After I hook them up, so to speak, with their defense counsel, my role is quiet for quite a while. I'll get copies of important documents and updates about what may be important that's happening in the case, key developments. But mostly I won't really hear from the defense counsel or the insured until later on, and that later on time is usually when the matter has gotten to a point where it's about to settle or is about to become a lawsuit. Any key development time. So the reason that I get involved when it comes time to the settlement is because just like with your car insurance, you have a deductible. And so under EPLI policies, the insureds have a retention obligation. So basically that just means that the first X amount of dollars, first $10,000 is the insurance responsibility. So they'll have to pay the first $10,000 in the attorney's fees. Or if they're able to settle it within $10,000, then they would be responsible for paying for the settlement. So obviously I get involved if a lot of times because usually settlement will occur above whatever their retention or deductible is. And the reason I'm involved is because I am tasked on behalf of Beazley with making a determination as to what is the appropriate amount to pay for this particular claim, given various factors such as whether there's any merit to the allegations. Believe it or not, people actually do discriminate. Sometimes it's true and sometimes it's not, so it depends. And whether or not there would be significant defense fees incurred if we had to go to court, if it got out of the EEOC stage of proceedings. So there's a lot of factors that go into it, and so I make a decision at that time to decide whether or not to settle. So my day-to-day varies a lot, and a lot of it is really making initial contact with the insurance and communicating with defense counsel and the insurance to understand where each claim is in the process, so that I can be prepared to make a prompt decision about how much and if we should put up funds for settlement.
Which I've had to call her before and talk to her about things like that. So as many of you might have heard, I mean, cases don't go to trial that frequently anymore. I mean, many of you probably have these ideas of being this, this trial attorney and standing up before the jury and getting to exercise all your trial advocacy skills, but it just does not happen as much as it used to. And so Christina brought up some very good points. There's a lot of discussion, negotiation, counseling, advice regarding settlement. So someone like me, not only do I have to convince the client that they need to settle this case and not go to trial, but I got to convince her to give me some money. And so as a defense attorney, just handling a garden variety vanilla lawsuit, you've got to have good communication skills, because you've got two clients basically in a situation like this. You've got an insurance company paying the bills, and then you've got the client who wants to fight it on principle. They didn't do anything wrong. They're not giving you a dime. Well, it doesn't always work. So if you guys have the opportunity to take classes in counseling or negotiation, communications, mediation, things like that, I highly recommend it, because I think that we can all agree the way that the California budget cuts have affected our courts means that there's just not as many courtrooms anymore. We don't have the same availability to bring these cases to trial that we once did. The judges, unfortunately, they have their hands tied and they have to push us to settle. And they will do everything to try to avoid a trial, like giving you one 4 years from now. A trial date 4 years from now, I mean, you have to settle. There's no way. I mean, her bosses will kill her if she keeps open a file for 4 years. My bosses will kill me. The client will be upset because they're paying legal fees for 4 years. So those are some considerations to think of when you think of what area of the law you might want to practice in. On the state court and federal court level here in California, we have been affected by budget cuts. So that means more cases are being settled. Now, Frank is in before the Workers' Compensation Appeals Board. There's changes in the work comp law all the time, right? And those cases still just keep coming.
Yeah, there was just a new Senate bill passed that was effective 1/1/13 this year. And they pretty much reform the system every couple of years, depending who's in the legislature.
Sure. But I mean, you've got a high volume business, right? So even though there have been budget cuts and things like that, there's still a lot of work in your area.
Yeah, what usually happens is, right now the trend is going more conservative, more employer-friendly. Traditionally, the comp system has been more employee-friendly, and that's caused a lot of, I'm sure Christina can tell you why, increases in premiums and things like that. So now they're trying to go a little bit more employer-friendly, but what ends up happening is that the applicant bar usually finds a way to get around the new regulations, and then we have a pretty liberal Workers' Compensation Appeals Board. The judges are pretty liberal, and they find ways around the new regulations, and they make new case law, and so that leads to more litigation.
And so that means for those of you who may be interested in pursuing a career in employment law, maybe you haven't considered workers' compensation before, but there's a lot of jobs out there. You might notice when you're looking through the classifieds or whatever articles or whatever journals are out there these days with the various jobs, but workers' compensation jobs are out there, and they're a high volume business. The cases come in a lot. And Frank, you have how many files right now, probably?
80 files.
80 files? I probably have anywhere between 20 and 40 on average. How many do you have, Matt?
Well, I have companies. I represent companies, so I don't necessarily have files. But
Right, it's very different.
Yes, it's
Yeah.
very different. So I could end up having open projects for those companies, but they would never be as much as at any one day. But usually it's like 4 or 5 things on every week, and things come through by phone on a regular basis. And some months are better than others. December is very, very busy for us because all executive comp and all, everything in writing has to be done before the calendar tax year, than the company tax year for tax purposes. So Christmas is horrible for me as a life thing.
You bring up a really good point, which is the work-life balance. I mean, that's something that I don't remember anyone telling me other than, oh, you're gonna have to work a lot. You know, oh, you're gonna, if you wanna make the big bucks, you gotta work a lot. But it's more than that. For example, most firms, especially on the defense side, some plaintiffs have billable hour requirements. You guys may have heard of that. My firm requires 2,000 hours a year. So that means billing 40 hours a week. Billing. So that means working 60 or 70 hours a week to bill 40, because you can't bill for when you're making copies, or when you're going to the bathroom, or when you're talking to your neighbor, or when you answer the phone call from your mom. So you got to work more, and it affects people. Matt and Frank have completely diametrically opposed types of billable hour requirements and their work-life balance as a result, because Matt is a transactional attorney and Frank is a litigator. So maybe you can kind of give an example of that.
Our billing requirement's 1950, even though I'm not a litigator. It becomes very difficult because although Sedgwick is a good litigation firm, they don't have an internal transaction department that is as strong as some other firms. So I have to go out and I do a lot of speeches. I go and talk to companies about their ERISA problems and filing requirements.
Does anybody know what ERISA means?
Yes, and I was going to say, okay, ERISA is retirement income
Let's
or
see if they know.
employment.
Let's see if they know.
Oh, okay.
Yeah.
Yes.
Employment, retirement, insurance,
Income.
security, income, the Securities Act.
Okay.
Yes. Congress in the 1970s essentially decided that they wanted to give some protections to employees because a couple, I think, big companies went under with supposed pensions, and those employees ended up with nothing. Therefore, in the 70s, Congress actually did something. Hey! And they tried out this act, and they dabble with it periodically, but it's mostly very, very regulated. The regulations is probably about 90% of what I have to continue to read. Their interpretation of the regulations, which is sometimes peculiar. I'm sure in ERISA, maybe it feels a little
Plenty of
better.
places it's
Yeah.
peculiar.
Like, did you read the same thing? But
So you
but
still have to bill almost as much
yes,
as I
and
do.
I have to go out, and my clients are my clients, which is actually a good thing for attorneys, because a lot of attorneys who are litigators don't have clients that follow them from firm to firm. I'm lucky enough that I have a good base of the clients that do that. But at the same time, you always have to go out and find more clients and new clients and better clients, because some clients don't always pay on time. Sometimes they go out of business. I had a lot of construction clients. But everything I'm doing to go out and get business is not billable. So you go to a conference for 3-4 days, that means you're going to have to work weekends to make up those 3-4 days, because I still have to bill those 8 hours. And plus, my clients, I have to have a really good relationship with them. So they call me periodically to talk baseball. I can't bill them for baseball, unfortunately. But at the same time, it's important for me to keep those ties and to make sure that they're very, very comfortable calling me. Because a lot of times they talk to me and they say, I just wanted to run this by you on my way home. And I want them to have that, because in the last 2 days, I had a client say, I'm tired of paying the auditors and want to get under 100 employees. I have these people shifting in from Japan, and it turns out they've screwed up their plan for the last 10 years because those people should have been in part of the 401k. So what was a quick question turned out to be a bigger project. It's easier for them to fix now rather through audit. So you have to, it's really difficult. I would have to say my work-life balance is very poor in the sense of that. However, I really do like the people I deal with because I get to solve problems. Usually even with the IRS and Department of Labor, it's not very adversarial. If I go on vacation or they go on vacation, I'm not going to see a motion or something happen during that time. We will give each other as much time as necessary to answer us. We always try to find solutions, so it's very polite.
It is so not like that in my work. So totally not like that. There's no excuse for vacations. I mean, if you take a vacation, who do you think you are? I mean, there's vacation. Now, my firm will say take your vacation, but opposing counsel don't care. They expect you to be on the email, on the phone, checking your voicemail every day. There's almost no excuse for it. So it can be difficult. But even on the plaintiff's side, there's even some more challenges because sometimes, I mean, you have to go out and find these clients, or the clients are finding you and trusting you with their personal employment issues. And so
well, let me. My job running the clinic is a little atypical, so I don't want to focus so much on that because I spend all my time teaching you in addition to working with you on cases, so that's not your run-of-the-mill job. But I certainly see a lot of students come to me with questions about work-life balance. It's very much in the news, and I think it's true that when we grew up as lawyers, we just assumed we'd have none. And I think it's a very valid concern. So I want to address a couple of things. So I've worked in a small private practice when I was first a lawyer, which sounds a lot like your situation. I was litigating all the time. There seemed to be no vacations. It was an office where we did employment discrimination, so it's not a traditional billable hours in the way that other folks on the panel have described, because we often did what were called fee shifting cases, where if you win the case, you're taken on a contingent basis. If you win the case, the defendant pays the fees. So it's not so much billable hours from within your firm, but you have to keep very careful track of your hours in terms of contemporaneous time records in case you do a fee petition. And a lot of financial ups and downs are very frequent in small firms like this. Everybody has a credit line they operate on. Because you can go for a long period of time without a lot of resources and then have more of a windfall when a big case settles or is resolved. So I think that any kind of litigation practice is probably the most, not to undermine how challenging yours is very challenging in terms of work-life balance, because you don't have a lot of control over when things happen. But I do want to say, if you're not sure whether you want to do litigation or something else, and that might not be something you figure out for a while, I do think it's a good idea to get litigation experience early, because I think it's a hard thing to plunk into when you're more senior. I don't know if other people agree with that. I think to start out not really having ever cross-examined a witness when you're already 7 or 8 or 9 years out of school, I think puts you at a disadvantage. So I think it's a good idea to do it first in whatever setting. It might not even, it could be in a public defender or a DA's office where you get those skills. And then if you decide you want to move on to transactional or policy work or something, you have it under your belt.
Absolutely, that's totally true, because it's certainly something that you may know people who are going to work for the big firms, you know, the big ones where they make the big bucks. Sometimes those associates are sitting in rooms doing document review and dictating for years and typing up memos and doing research. It's stuff that you could do right now. I mean, frankly, it's very honest. Whereas if you work at a more mid-sized firm, or like, Christina and I actually used to work at the same firm together. I'm still there. But if you work at my firm, we have 500 attorneys across the country. But in my first year, they had me appearing at case management conferences. I went and sat in a deposition my first year. I didn't conduct it, but I sat in and listened and took notes and things like that. They had me doing what I went to law school for, to be a lawyer. So if you really want to litigate, and I agree with Professor Seville, it's a great experience to get right off the bat. And also, if you work in a firm that has enough attorneys, you can always go with people, even if you can't bill for the time. Hey, I want to tag along with you and see what a deposition's really like. Can I go with you today? Or, oh, I hear you're in trial. Can I go with you? Because law school doesn't prepare you for those things. It's unfortunate. It's just the nature of the beast. It's how law school is. It's more theory, and not, there's some practical experience, but it's just not as much as I think that we actually do. It would be difficult to teach that in a classroom. But so it's highly, I think, Christina, you started out doing litigation, and you don't do litigation anymore. Are you glad that you got that experience?
I'm definitely glad I got the experience, and I think that, you know, one thing that I may not be clear, because I was trying to sitting here thinking about when I was a law student, if I really understood what an in-house counsel was. Because everybody, I felt like in law school, a lot of people aspire for in-house counsel, so if anybody's thinking about that, that's kind of what I'm doing, because I'm in-house with the company and I manage litigation. So even if, you know, I'm not working for, you know, Gap or Google or any of those, but in order to get those positions and in order to get a job in-house, you need to have a certain amount of experience. So I could not have gotten my job without having had the litigation experience. They wouldn't have wanted me because I wouldn't have been able to effectively manage the claims and manage the cases that come to me if I didn't have the experience I do. I'm like a recent example I'm thinking of is a friend of mine works for Yelp in town, and they were, I don't think they still are, but they were looking for somebody to fill a role in their legal team. But one key requirement of that person is they needed at least 3 to 5 years of litigation experience. They didn't care if they had any transactional work experience, even though a lot of the work that person would be doing was having to do with mergers and acquisitions. They still wanted that person to have the litigation experience because they wanted the wide range of experience. And so that's one thing to keep in mind of why getting that under your belt is a good thing.
So sometimes that means that at the outset or in the very beginning, the work-life balance issues might be more prevalent because obviously once you're down the road a little bit, you start working with people and you figure out how to manage things better. And I think that in prior discussions that we've had, we've learned that actually workers' compensation can be quite friendly for a good work-life balance. Even though you're in the car some days from 8 to 8, there's a little bit, like you said, Frank, before you mentioned things like with working mothers and your field being good for people like that. It's a fact that that's a problem in the legal industry, finding a good work-life balance for people who need to work part-time or for people who have other obligations in life that preclude them from working 80 hours a week. And Frank, I think you've mentioned before that your field sometimes helps with that.
Yeah, I also started out with civil litigation, but just to mention the experience, just to add to that, I thought the experience I had in civil litigation was invaluable because when I was a civil litigation associate, I think I took 2 depositions in like 3 or 4 years, and I was at a medium small firm. And then when I started doing work with Prof, I think now I average 20 to 30 depositions a year. So it's a huge difference in the amount of experience you get. I have noticed, as I was mentioning to Amy, that I see a lot more female attorneys, especially female attorneys with kids in the workers' comp field. I think it's a little bit more flexible field. I can pretty much handle my own hours. I set my own hours. We don't have vacation days in my firm, but I can pretty much take vacation anytime I want. I just have to make sure that my calendar's covered. So I just have to make sure all my court appearances are covered if I'm going to be out that day. So I think of all the litigation type jobs, I think workers' comp litigation is probably like the least like litigation.
True, but you still are, you take depositions. You know, and also one of the interesting things, I think, Vince, wherever you are, we were talking about this beforehand, one of the coolest things about workers' comp is Frank knows everything about medical conditions and medical stuff. Like, it's such a weird thing, just like how Matt knows everything about the tax laws and everything. They're employment attorneys, but they have this opportunity because of the practice area they're in to be very fluent in a completely different area of the law. Frank deposes doctors on a regular basis and has to know all the codes and all the diagnoses, and he knows all the big words and things like that. And so it's also very interesting, isn't it?
It is, but that's not. I like dealing with a lot of different personalities, and it's kind of feel like a street lawyer. There's a lot of negotiation and just kind of horse trading, So, and I'm not in the office a lot, which is my favorite part of the job.
Amy, I wanted to jump in with something that we haven't really touched on, which is government work.
Yes.
Because I have found, particularly in terms of feedback from students in the past who are looking for work-life balance, that it is sometimes a good place to go. And there's a whole range. Because if you, for instance, if you become a lawyer at the state, essentially the Labor Commission, the Division of Labor Standards Enforcement, you are litigating all the time. It's like being the public defender for workers with wage and hour claims. You get a lot of litigation experience, but it is still a more controlled work-life schedule than if you're in private practice with billable hours and the financial pressure of doing it. I think, Brian, you can jump in if you think I'm wrong. I think that's true at the National Labor Relations Board too, that you're litigating. It's administrative, but it's a fairly high-level administrative in the sense that the rules of evidence apply. And it's still a government job, and I think any government job has some confines to it that are a bit different. So, and then there are a whole host of government jobs in the employment field that are not purely litigation. They may be policy related. You could be drafting regulations, working on legislation, a whole host of things. And it's always a good idea to keep your eye once you're out of school, or when you're in school in terms of internships, but to make sure you check all of the websites. So there's a U.S. website that encompasses the Department of Labor. There's a state personnel board that encompasses everything. You can put yourself on email blasts for anything you're interested in, because for civil service jobs, you have to generally get on the list. You have to take some kind of a test, which is sometimes a very pro forma test. But it's a process. Oh, I'd love to go be a lawyer at the Department of Fair Employment and Housing. Well, too bad. You didn't pay attention and get on the list that then turns up a job 3 years later. So it's no harm done to get yourself on an email blast about when there's a job. When you have a few more years out, you could become an administrative law judge. And these jobs actually exist, even in the budget crisis. You just have to really stay attuned to checking in about them.
That's absolutely right. One of the things that's happened, and I'm sure Professor Seville can comment on this as well, but in the past year, the EEOC and the California, the Fair Employment Housing, I think it's a council now, right? I think they just changed the term from commission to council. Big deal. But they are amping up enforcement efforts. This is something new. That means they're hiring. They are bringing in attorneys because they need to prosecute these employment claims on behalf of employees. Now that's in the past, just briefly, I mean this is something I regularly handle. In the past we've got an employee who gets angry, they go and they file the form with the government agency saying I was discriminated against. That's usually when Christina gets the copy, bless you. She'll get the copy of it, hopefully. But at that point there's two things that can happen. A right to sue letter can be asked for and immediately given, which means then they can file a lawsuit in court, or the Fair Employment Housing Council or the Department of Labor or the DLSE or whoever may elect to pursue those claims on behalf of the injured employee. In the past, we just see right to sue letters left and right. I mean, they just never take them on because it's not worth their time and they don't have enough manpower. I mean, some EEOC files I have are a year or 2 years old and they're just sitting dead because there's not enough people. So we've heard through the news outlets that over this next year, they're going to be increasing and amping up these enforcement efforts, which will lead to inevitably the hiring of more people to come in and handle those cases, bless you, on behalf of employees. So keep your eyes open for that. I happened to have a clerkship. So I took a clerkship right after law school and worked with two Superior Court judges in LA. And wow, that was the best job I've ever had. I can't tell you how much I learned, and to this day, I will not file a discovery motion unless I have exhausted every effort, because I remember what my judges would do when people would show up before them. So it's invaluable. Great government benefits. I mean, yeah, the pay wasn't super great, but great benefits, great experience. And people have always commented on it when I've turned my resumes in anywhere, because they know it's very hands-on experience. You're not going to be sitting in a room looking at documents for 3 years. You're probably going to be out there interviewing people and taking depositions and doing actual legal work, which is why we all went to law school, you know. So keep that in mind, and that also, it's probably a little bit better work-life balance than working for a big firm. And like you heard, I mean, Matt's in his office all day, except for when he's meeting with clients, whereas Frank's in his car all day. So there's a different level of flexibility between those two types of jobs, which is something that you should consider. What kind of person are you? Are you okay with sitting in your office, you know, every day with just having sporadic meetings and being mostly on the phone? Do you like that? Some people would prefer to do that, you know, the paper pusher type lawyer. Nothing wrong with that, and there are those jobs out there. Bless you.
That's wrong with me. I think I'm allergic to school, sorry.
We all are.
But also that does bring up the other subject, which is you're going to find a lot more jobs in Frank's area of the law than you are in Matt's, right?
Yes, it's very difficult. Nobody grew up to think that they wanted to be a ERISA attorney. Work with companies to make sure they keep their tax qualifying status so they don't have to the employees don't have to pay taxes on the benefits they get, or work with executives to make sure they get all those extra sexy options that they all want, but they don't really realize it might not be the best idea for them. It took a lot. I basically went to law school, graduated, and I came here and got my LLM. And while I was getting my education here, I took a ERISA course. And it just happened that my first job was a boutique ERISA firm. Therefore, automatically, I was an ERISA attorney. Regretted it for about 6 months, and then after about 6 months, I was like, this is actually okay, because I now sort of understood everything that maybe the professor wasn't totally getting through to me, although I got an A, which is shocking because I must have knew what to write, but it's a lot different. I think sometimes when you go, you understand sort of like the tools you need, but you don't understand how it actually applies in practice to the client, because you have to be a little more nuanced. Nothing is as black and white. A lot of times I have HR people or even CFOs call me with problems, and they don't want to look bad. And so a lot of my job is trying to make things look like it's not their problem and not their fault, so they get to keep their job. So the CEO or someone else doesn't get mad at them. And that's perfectly acceptable, and I've learned how to nuance things, write emails that say things but don't really say things. So communication's huge, and working with your clients are huge, but yeah, it's a very difficult thing. And if I work a lot with ESOPs, employee stock ownership plans, where employees buy out, buy ownership within companies, and you could probably put us in, everybody that does a lot of that work on one particular plane, and if they crash, ESOP industry would probably go away, which the Department of Labor might like sometimes. But it is a very niche area, and it's sometimes very difficult to get into.
And the same with Christina's area of the law. I mean, you're in-house counsel, and again, that's typically not something that people are coming straight out of school and doing, because a lot of those type of jobs would like you to have some experience first, just some lawyering skills, whether it's litigation or not, although we all, I think, the consensus is try to get some litigation experience if you can. And in my field, and just, again, the garden variety, vanilla, labor and employment disputes, there's jobs out there. They're certainly out there, and I think that, as I was talking to some of you before the program started today, it's really important to know people. Because the market has fluctuated so much over the past few years, it really does matter who you know. It has come back to that kind of environment. So I strongly encourage you to get involved in organizations. Work with your career services office, because I'm sure there's tons of different programs being put on. Get involved in the bar associations. The ABA's annual meeting for the labor and employment section is here in August. This place is going to be swarming with labor and employment attorneys, this city, for a week. Pull the information and look, because I mean, sitting in a bar after a day of convention with someone and just talking to them, that's a connection, and that is something that you will not get unless you get out there. So I highly recommend getting involved with places like the ABA and the Bar Association here in San Francisco. There's lots of different opportunities for you to just go to mixers. I mean, you can grab 3 or 4 of your friends and just show up and stand in a corner until you get enough guts to go talk to someone. I mean, I love to talk. I'll talk to anyone if someone approaches me, so whatever. But it's really easy. I think that you find that, I don't know, have you guys had similar experiences when you go to things like bar association functions and been able to approach, or even in your earlier careers, were you able to do that? Yeah?
Oh, yeah. I would actually ditto. I think it's incredibly important. Every job since my first job has always been a relationship now. And it was always through some association that I was a part of. And a lot of times, even within those associations, sometimes you're doing a lot of grunt work, making the organization work, like setting up conferences and other things. But those are all important, and people realize that you have a passion for it. And sometimes that's enough for them to start talking to you. The person I work with now is probably the best person within the ESOP world who knows the most. And I had a relationship and worked with her because I was in these associations, and I ended up getting opportunities to work with her later on in my career, and I got to work with her, and I still do. So those associations do open doors and open lines of communication with people you probably can't just call up on the phone and start working with, and they actually become comfortable. And she would, I talked to her weekly for like 7 years before we actually started working together, and that's how I got the job I'm at now, and that's where when I got into Thielen, I got there, and if we go somewhere else, it'll probably be based in part on her.
Yeah, I would echo that. From the plaintiff's perspective, there's an organization called the California Employment Lawyers Association, or CELA, that has all kinds of continuing education programs. You can join it. There's another, in between the Bar Association of San Francisco and the ABA is the State Bar, and there's a labor and employment section of the State Bar that I, for many years, served on the executive committee of. It's labor management and neutrals, like arbitrators and mediators. They put on continuing education programs. I always give my students $5 you can join this section. You get their publication, you get notice of their programs. Their programs are expensive. We've negotiated a student rate. If you can't afford it, call them up and ask them for a scholarship. They'll probably give it to you. It's another, they're really great continuing education programs. So I think all of those things are important. But I just want to jump in and mention one other thing. Everybody knows it's a tight job market. It's really easy to just put your head under the covers and decide, I can't do this. So a couple of tips that I have are, if you know that you want to practice in traditional labor law and labor management areas, make sure you take a labor law class, whether you take it here or somewhere else. Make sure you get a summer job that's, like Ryan did, that's at the National Labor Relations Board or at a union firm or at a management firm that does labor law. Not everybody knows that some people have, I love to call it vanilla, I don't think of these things as very vanilla, but you know, if you want the broad spectrum, you just take some general courses. But if you know you're interested in RISA or traditional labor law or workers' comp, build up your credentials a little bit. And if not, at least come talk to me or somebody else before you go into an interview and get a crash course so you know what you're talking about. So that's one piece, is understanding if you have a specialty interest to build your resume around it a little bit. But the other is to have an open mind and don't expect necessarily a completely conventional route into employment. I'll tell you my story and then a quick example of one of our students. I moved here from the East Coast, took the bar, and needed a job. And I started looking around, and I stumbled into initially some part-time contract work at a small civil rights firm. I walked in, they said, okay, we need you to go research this EEOC issue. And they had these books on their wall that were the BNA EEO reporters, which I had never seen. And they said, this is a good place to research it. And I'd never tracked these books before. So I went the next day, I went to I think the USF library, I found the librarian, and I made her teach me how to use these books. And I looked really smart when I went back in to do that research project. And I became an associate and spent my first 4 years practicing in a small civil rights firm with a slightly wild but amazing mentor who had been a very prominent civil rights lawyer in the South. So it turned into a job. I have a student from here who I referred to a terrific small plaintiffs firm, and then they had what was almost a clerical job. They sent it to me. It was a 15, 20 bucks an hour handling intakes. They said, it's not going to be a job. Don't get anyone's expectations up. I said to her, I think you will like these people so much that you should think about this. And she did it, and she did that for a while, and then they hired her to do contract work, and I just heard they've given her a 1-year fellowship. So it's about meeting the right people who you will love, who will teach you, and who can become mentors for you. Now, maybe you don't have the financial ability to take such a low-paying, short-term gig, but don't rule out that you can have a really unconventional path into your career.
Yeah, Matt says nobody grew up wanting to be a tax attorney, but I did. I have a degree in accounting. I wanted to do forensic accounting and tax and investigate tax fraud, and I got a D in tax in law school. Got an A in undergrad in tax and a D, and I went crying to my legal writing teacher because she was so wonderful, and she happened to be the labor and employment professor at my school. And she said, do you want to be my research assistant? You're a good writer. Do you want to help me out on some projects? I'm writing some articles. I'm writing a chapter in a book. You want to help me? It's $10 an hour. Yes, thank you, okay. And I fell in love with that area of law. And because of that, I ended up being a mentor for some first year that came in, and she happened to work at Baker & McKenzie, and she got me a job there as a law clerk with her. And you know, it was totally unconventional. It was not at all what I expected, and I loved it the minute I started actually working in it and getting the feel for it. And you bring up some very good points. Don't be afraid to get involved in different things. For example, I get asked to write articles all the time, and I don't have an associate that I can just be like, here, research this stuff and help me out. I need people like law students who would be willing to get a co-authorship on an article and help me write something, because you guys don't have to bill, and I do. So, I mean, you know what I mean? Like, look at things like the ABA journals. They're always asking for people to submit writings. Maybe you weren't able to do law review, but maybe you love to write. Get your name out there, submit things. There's the California Lawyer magazine, there's the LA Lawyer magazine, there's the Bar Association magazines, there's the ABA publishes magazines and journals. If you like to write, submit things. Get your name out there. That looks fantastic on a resume. We all know how much work goes into writing a scholarly article. Everybody does. It's a ton of work, and if it's well written, oh, you cannot teach good writing. I really think that, I'm sorry, you can teach it, but I think that some people are born with the ability to convey and to turn a masterful phrase, and I think that you can see that in writing, and it's a great opportunity. So don't foreclose opportunities like that too, because it is good to get out there and meet people face to face, but it's also a good opportunity to beef up your resume where you can, whether it be through a 15-hour-a-week seemingly administrative jobs at a labor and employment firm, or through writing an article, things like that.
Or, you know, I just want to slip this in. If you maybe don't like to write, but you don't mind editing, if you have that experience, what I did when I was an associate at the firm is I volunteered as an editor for State Bar. Each section has a newsletter or a journal or some sort of thing where they'll take and print articles because they don't have a lot to print, really. No, I shouldn't say that, but
It's actually a pretty good
I'm not sure of the
publication.
labor employment division that the bar does, but
It's a good publication.
right. So the publication that I did was for the real estate section of the State Bar, and you know, I think I volunteered maybe a year or two, just editing articles whenever they asked me to do it, and then eventually I became the managing editor for So I mean, and it looks great on my resume. I mean, it doesn't have anything to do with employment law, which is what I do now, but it nevertheless is a good experience because it shows that you are capable of, that you have a skill.
Right, and Matt, you give presentations, right?
Yes.
I mean, that's another opportunity. If you don't like to write, but you like to talk, there you go. You can get out there and work with an associate or a partner at a law firm and help out by putting on presentations for labor and employment groups. I mean, there's the Northern California Human Resources Association. There's lots of different HR organizations around the Bay and nationwide, and attorneys are constantly putting on presentations for them, whether it be continuing legal education or just other informational type seminars. And again, those are great opportunities to get involved and to learn more about the area of law too.
One thing I want to jump in around networking is to keep professionalism in mind. So if you do go to a continuing education program, don't go in your torn jeans. Bring a business card. If you're going to network with people, bring a card so you don't have to be, tearing off little Post-its and writing out your name. And then the other thing that I think, we live in a very informal era now, a lot of emailing, texting and so forth. And when you want to, let's say you meet someone at one of these conferences, you want to follow up, it's really important not to follow up with an email that's, hey, really great meeting. You don't have to have it be a formal snail mail letter necessarily. You could follow up with an email, but make sure it has an appropriate salutation, that you proofread it before you send it, because you're going to really not impress somebody if what they get from you is something with a lot of typos that starts out with yo. And we're all used to being very informal now, including the salutation being hi. But I don't think that's the way you follow up when you're trying to make a business contact, and you have to adjust the informalities to professionalize it a little bit.
Totally agree. It's very important. Communications is one of those things that, regardless of what area of the law you practice in, what government agency you end up going up against, who your clients are, how you get them, what you're doing, communications is key. We are all counselors negotiators and advisors. So I see we've actually gotten really close down to the wire here, so I think we got a class coming in, so we've got to get out of here, but we'll be out in the hallway in case anyone has any specific questions. I apologize that we ran out of time for group questions, but we'd be happy to answer them in the hall and to even give you cards in case anybody has a question you'd like to discuss in greater detail. But otherwise, thank you so much for coming today. There's a bunch of ADA materials here if you're interested in joining the student section. It's pretty cheap and there's lots of opportunities to get involved with respect to the publications, resume reviews, help writing cover letters and getting jobs, things like that. Thank you.
Thank you.